Hello, everybody. Welcome to Legal Aspects of Sports. This week, we're going to be talking about negligence. Negligence is a category of law that encompasses situations where a civil wrong has been committed, so a non criminal act. Okay, so this is civil, not criminal. Remember, in the last week, we were talking about the difference between civil and criminal. This negligence is in the civil realm, not the criminal realm. It involves conduct that is careless or intentional that results in someone getting hurt. Okay, either injury to themselves or injury to their property. Negligence occurs when someone sustains personal injury, but there is no intent to cause injury. Okay, unless it's an intentional tort, but that's a little bit different. So criminal acts are usually there's some form of intent. Negligence, there's no intent. Right? The injured party, as a result, doesn't seek criminal action, seeks monetary damages, all right, for his or her injury. So if they get into a car accident or if there's a breach of, somebody goes on their property, something like that, so damage to their house, so they seek monetary damages for their injury instead of a criminal act. There are four elements of negligence. So you need to be aware. In order to prove a negligence case, you have to prove all four of these elements. The first one is duty or standard of care. The second one is breach of that duty. Third is causation. And when we say causation, causation is two parts: in fact and proximate cause. And then you actually have to prove actual damages, that you are actually injured. If there are no damages, you do not have a case. All right, no matter how many times clients come to me like, I want to sue this person. I go, well, how did it affect you? Well, it didn't. They were wrong. Well, yes, they were wrong, but you didn't have any actual damage because of that wrong. So let's say a car accident, two cars bump, but there's no damage to the car. Well, there's no damage to the car. You have no actual injury. So you can sue because they were negligent, but you're not going to win because there was no damages. Fair enough? All right, so each element must be established and proven in order to recover monetary damages. If one of those elements is missing, the case fails. All right, so you need to prove all four. If one is missing, the whole case fails. All right, standard of care. What do we mean by that? Standard of care is the duty or responsibility owed by one person to another. All right, so it's the responsibility you have to the rest of the world. You have to, in the sports context, you have to keep a reasonably safe sports environment for those under your care. So if you're a facility manager or a sports manager, you need to keep the place safe as best as you can. You need to keep the participants safe, the patrons safe, and the workers. Okay? How do you establish standard of care? How do you know what the standard of care is? How do you have guidance on what you need and don't need to do? Well, you could look at case precedent. Remember, we talked last week about case precedent, stare decisis. You can look at prior cases and see what the law is, and sometimes it'll set what the standard of care should be. You can look at rules and regulations. All right, what are the rules? What are the regulations? Well, that'll set the standard of care. If the rule is A, then you need to do A. If you don't, then you breached your standard of care. You need to look at state and federal laws. All right, just like last week we were looking at common law, we look at case precedent. We look at statutory law, we're looking at state and federal laws. All right, so look to the laws. They may set the standard of care, what you need to do. All right, and then if there's no law in this area, you may look at what the practices are in your community or the industry standards. Like in the law business, we have what our industry standards are. We need to be ethical. We need to not steal from our clients. We need to keep our trust funds in order. That kind of stuff. You look to the industry to see what the standard is. So how do you set the standard of care? You got to look around and see what's out there. See what cases are out there. See what laws are out there. If there are no laws, what the rules are. So what the NCAA rules are. The NCAA sets what the standard is. If there's no rules or regulations, you look to community practices. You look to regulatory agencies, other professional organizations. All right, within that professional organization, there may be manuals. So you read those. Oh, this is the standard of care. I get it. This is what the least amount I need to do in order to keep everybody safe and not get sued. And lastly, if there's no standard of care set anywhere through statutes, case law, federal rules, policies, or anything like that, you can ask an expert. All right, what I mean by expert opinion is somebody who is knowledgeable in this area, and they will come in and give their opinion on it. So, all right, did the person breach their standard of care? Well, the expert may say, well, listen, I've been in this area for 40 years, and this is how it's done, and this is the way it should be done. And based upon my expert opinion, that person either breached their standard of care or didn't breach their standard of care. Okay, so I may ask you on the quiz, how do you establish, name 4 or 5 different ways to establish standard of care. If you guys who've had me before know, right, 4 of these down, you'll get 4 points. Fair enough? All right. Additionally, if the defendant is one who violates a statutory duty, it is deemed negligent per se, and therefore negligence as a matter of law. All right, so this is a little different. There may be certain laws on the books that automatically say if you do this, you violate. You've breached your standard of care, and that's deemed negligence per se. All right, per the statute, negligence per se. And therefore, it's negligent as a matter of law. The only thing you need to next analyze is what damages are. An example of this is would be a rear-end collision. All right, somebody hits you from behind in a car accident. That's negligent per se. That negligence is found. That person is negligent just because of the fact that they hit you from behind. Therefore, all you need to do is look to the damages, and you've made your case. Okay? So all those other ways are to establish a standard of care, but a statute may say that this is the standard of care, and if you do it, you violated the law, and that's negligent per se. Okay? The next element, so you have to find what your standard of care is, and then you have to prove that they breached that standard of care, breached their duty. Okay? Plaintiff must establish that the defendant failed to conform to the duty of care owed to the plaintiff. There was a standard of care set, they breached it. Plaintiff must show the defendant's conduct imposed an unreasonable risk of harm. Okay? Again, how do you determine this? Right? This is the question always. Well, again, you look to the same place you looked before. Look to the case precedents. Look to see if they violated any rules or regulations, violated any state or federal laws. If they did, well, then they breached their standard of care. See if they violated any federal regulatory agency guidelines. Well, if they did, they may have breached their standard of care. Professional associations, violations of agency policies, or just the fact that their actions posed an unreasonable risk. Right? Just their actions alone may be the breach. All right, so how do you set the standard of care, and then you got to look to see whether or not they breached that standard of care. So we find it in pretty much the similar places, and then you've met your first 2 elements. The third element is causation. Okay, so you have standard of care, breach of that standard of care, breach of that duty. Third element is causation. All right, did the act or inaction of the defendant bring about the injury? If it was the cause of the injury, well, then I think you've proven it. There are 2 types of causation that must be found: cause in fact and proximate cause. Now, those are 2 different levels, so let's go over those. Cause in fact, there must be a reasonable direct connection to the defendant's actions or omissions. Basically, but for the defendant's conduct, the plaintiff wouldn't have been injured. All right? So, but for the plaintiff being negligent, the defendant being negligent, the plaintiff would not have injured. All right, it's pretty simple. But for the defendant running the red light, he would not have hit the plaintiff's car. All right, easy. There's a direct connection between the defendant's actions and the resulting injury. But for cause in fact. The second is proximate cause. This is a little different. Defendants are liable for all consequences of their negligence if no superseding intervening cause occurred. All right? So let's say the same car runs the red light, hits the car. Well, but for the defendant's negligence, the first car wouldn't have been hit. Now, what if that car's tire pops off? The plaintiff's car tire pops off, rolls down the street, and hits some child riding his bike. Well, yeah, that's a consequence of their negligence. All right, the defendants are liable for consequences of their negligence if no superseding intervening cause occurred. So, run through the red light, hit the car, car's tire pops off, rolls down the street, hits a kid on the bike. Well, that's proximate. All right, it's foreseeable. Foreseeable that if a car gets hit, a tire might pop off. All right, that injury was foreseen by the defendant, or reasonably should have been foreseen, and it was a natural and probable result of that negligence. Well, probable, it could happen, right? That tire could pop off. Now, it may not be proximate cause if that car runs the red light, hits that plaintiff's vehicle, that tire pops off, hits that kid on the bike. But the person just left the tire store and the tire store forgot to put the lug nuts back on. Ooh. Now the defendant may not be liable for that because that would be a superseding or intervening cause. The failure to put those lug nuts back on may save this defendant from the injuries to the kid on the bike. Still have to pay for the injuries for the person that he hit in the car. But the tire popping off was a superseding intervening cause that the defendant really didn't foresee. Right? It wasn't natural and probable result of that negligence because you expect everybody to have tight lug nuts. Make sense? If you have any questions, you always know. Give me a call. All right. The fourth element is damages. For any cause of action, there has to be some form of injury. Proof of your damages are essential to prove a case. Okay? As many of you know, I'm a judge arbitrator. Damages are essential. If there are no damages, you don't have a case. All right? So you actually have to prove that you were hurt somehow. And you have to show evidence that you were hurt somehow. If there's no evidence, I can't give you an award. Right? There are many types of damages, but the four that you're mainly going to be concerned about are compensatory, loss of consortium, punitive, and equitable damages. All right? Compensatory, they are to compensate you for your loss. Compensatory, to compensate. All right? You're just going to be compensated for your loss. So if your car was damaged because the person ran the red light, to compensate you, we're going to pay you for to fix the damage to your car. All right? If you were hurt, may pay for your doctor bills or lost time from work. They're going to compensate you to make you whole again. All right? Loss of consortium, it means damages to those who were around you who were affected by this. All right? So let's say you're married and you were hurt and you were laid up for 6 months because of the injury. Well, those around you were affected too. They may have had to take time off from work. They may have had extra expenses, so they're entitled to some form of compensation too. Okay? Punitive damages are just what they mean, punitive, to punish. All right? These are forms of damages not given out too frequently by judges, but they are. They are to punish the other side, right? To punish the defendant, especially if there's been a series of negligent acts. Right? Typically, if there's one negligent act, you're not going to get punitive damages. But if there's a series of negligent acts and you knew that your conduct was negligent, the court may come in and put punitive damages on you just because you knew this could happen. And the last are equitable damages. All right, this is kind of interesting. This is maybe not used all that much, but let's say you want to buy a house and you have a contract for the sale of the house, and then the homeowner says, no, I don't want to sell it. Well, equitably, you should get that house if you want to. So there may be certain forms of other damages to force people or to do something or not to do something. All right, there may be an injunction. If a coach wants to breach their contract and go coach at a different school, you may have an injunction. That's an equitable damage to stop them from going to that other school. They're your coach. They're under contract. They can't go coach somewhere else. Fair enough? Thank you. All right, this is video part 1 from Negligence. If you have any questions, as always, please feel free to give me a call, text me, or send me an email. Thank you.